mention this matter. My lord, absolutely for personal inconvenience of my colleague, the affidavit could not be prepared. My lord, very short time I am praying for.
When do you want?
My lord, only sir, one. My lord, for me it's an very urgent matter, but then he has got some difficulties for a short date. Well, can it be fixed on 5th of March?
Problem is the rooster has not come out.
No, I could understand that, my lord. I was also thinking because Justice Kardak often may be out of station also.
Okay, we'll fix it tentatively. If he's there, we'll take up.
My lord,
If not there, when he comes, we'll do.
my lord, and it may be marked as parted.
Okay, on request made by Mr. Shishir Datta. Yes, Datta, the new counsel for the petitioner, for the appellant. Released on 5th March as parted.
I'm sorry for the inconvenience. Obliged.
Was terminated from his contractual post. This post is going to be filled up by next week, Lordship. Termination matter, Lordship, urgency is
That's
there.
a different matter now. 28.
May I please, Lordship, on matter is listing or urgent listing, Lordship, there's an infractious matter, Lordship. I'm appearing for respondents, Lordship, for tomorrow, Lordship. Interim order
This
is,
matter, what is the urgency?
Lordship, admission will be, advertisement will be issued, Lordship, and subsequently, Lordship, it was been, selection was made, Lordship. Selection will be held on 25th February, Lordship. That's why, Lordship.
Have you informed petitioner's counsel?
No, Lordship. Instruction received, Lordship, that matter became infractious. Age relaxation purposes, Lordship. That has been done, Lordship.
Basically, the petition was filed to relax the age bar. That has been done by the government. So he is eligible. So by age is concerned. Therefore, I will
Okay.
For tomorrow, Lordship.
My lordship, item number 9, my lordship, kindly pass over the matter, order day only, my lordship.
Item 9.
Item 9,
Yeah, Mr.
N Islam.
On request made by N Islam, then the counsel for petitioner, list after 1 week.
No, my lordship, you fix the matter Monday, my lordship.
Why Monday? You want an adjournment today and you want a date fixed.
No, my senior is not available today.
So that's
okay.
why we'll have it after 1 week. Yes,
Obvious.
after-
With please, your lordship, with the consent of the other side, I
Oh.
beg to mention item number 6 of the daily list, lordship.
Yes.
Lordship, Mr. Pathak was supposed to conduct this case today, my lord, but
Oh.
his flight got delayed, my lord.
Oh,
Next week.
Next week, lord.
Pathak is coming from where?
From Itanagar, lordship.
Itanagar, there's no flight. There are no flights from Itanagar now to Guwahati.
Pasighat, lordship.
Pasighat.
Pasighat.
Okay, on request made on behalf of Mr. P. Pathak, not a counsel for the petitioner. When?
Lordship, next week, any date.
Not next week, we'll say after 1 week. Okay.
Obliged.
May I please, my lord? My lord, I'm praying for listing of a writ petition, my lord. My lord, can it be listed on 6th of March, my lord, for admission?
Okay.
Obliged, my lord.
Deputy Lordship. Lordship, I am praying for listing one motion matter, my lord. I have filed on 20th, my lord.
20
Yes, my lord.
of this month.
So this matter may be come tomorrow, my lord. There is an urgency. This is the matter of selection and appointment, my lord.
Selection appointment of what?
A rifleman in Assam rifleman.
So we'll have it on Monday,
The result may be come to shortly, my lord. That's
Monday.
my lord. Deeply held.
May it please your lordship. Lordship, I beg to mention WPC 509/2023 for listing.
When?
Lordship, may kindly fix this, list this matter on 4/3/2024. Obliged.
My pleasure, Lordship. Lordship, in item number 8, today we have filed affidavit in reply to the affidavit in opposition filed by the respondents. That will kindly be called for a report.
When did you file?
We have filed it today.
You are filing or you have filed?
We have already filed this morning, Lordship.
That will be difficult, isn't it? It may be defective also. It will be difficult to call today. If you have filed today, it will be difficult.
Let us take a chance, Lordship. Give us a chance.
Any urgency involved?
Yes, Lordship.
What urgency is there?
Urgency is that he has been terminated till now and he is not in the service.
That is not an urgency. We will fix a date and list it on that day. Your good name, please.
L. Sangam, Lordship.
Mr. L. Santam, Learned Counsel for the petitioner submits that they have filed an affidavit in reply to the counter filed by the respond number
All the respondents.
by the respondents. So registry to verify and place the same on report and list the matter on six months.
Lordship. Masuklah.
May I please your lordship,
Hmm.
with the consent of the opposite party, I beg to mention item number 3 to pass over the matter for the day.
Pass over the matter.
Yeah.
For the day.
Yes, lordship.
Your good name?
P. Kakhalari.
Hmm?
P. Kakhalari.
You are appearing on behalf of?
P. Mohanto.
Okay, on request made on behalf of P. Mahanda, the council. List the matter after 2 weeks.
Okay,
After 2 weeks.
thank you.
Please, your lordship, I'd like to mention item number 12, lordship. As the conducting council is out of station, lordship, kindly matter may be passed over for the day.
Who's the conducting council?
M. Dev,
MS. M. Dev.
M. Dev.
On request made on behalf of MS M. Dev, Learned Counsel for the petitioner. Yeah, 2013 matter. List after 2 weeks.
Yes, lordship.
Hmm.
Objection.
Melody, my case is WPC 2193/23. It is for last posting was on 13/9/23, but it is against FCI. FCI is supposed to submit the evidence. Affidavit they have to submit, counter affidavit. For that, I wanted it. It is already delayed,
13th March.
13th March.
Yeah.
Twenty-one of supplementary motion.
Yes.
May I please?
Hmm.
Lordship, the petitioners before your lordships, my lord, they are presently working as a protection officer, my lord, under the Department of Women and Child Protection, Assam. My lord, the nature of their service, my lord, it is a, my lord, contractual job. It was appointed, my lord, under a scheme formulated by the central government. That scheme is now called, my lord, Mission Vatsalya. Mission Vatsalya.
Hmm.
My lord, earlier it was ICCPS project. It has been renamed subsequently in the year 2022 as Mission Vatsalya. So before going to Mission Vatsalya and the other facts, my lord, I may point out, my lord, one fact. My lord, there are two types of service, my lord, maintained by the Women and Child Department, Assam. One is, my lord, regular cadre. They are appointed either through the directorate, selection process conducted by the directorate or by the government, or in case of class 1 officers, my lord, it is conducted through APSC, my lord. And the other cadre, my lord, the other batch of service holders, my lord, they are in a contractual, my lord, job, but their nature of duties and rankings in service, hierarchy in service, my lord, more or less, my lord, same. Resultingly, my lord, the educational qualification and other things are also similar, my lord. Now, lordship may kindly come to page 21 of the writ petition, my lord, Annexure 1. This is, my lord, the initial advertisement in the year 2013. Has your lordship got it?
Yes.
Annexure 1, my lord. This is a type copy, my lord, of the relevant portion because the original one is very small one, my lord, letters are very small one. So I will read the relevant portion, my lord. The post the petitioners are presently holding, that was, my lord, protection officer for institutional care for district child protection. And, my lord, the educational qualification which was prescribed at that point of time, my lord, that is relevant here. Graduates, postgraduates, preferably in social work, psychology, sociology, law, development studies, home science, with knowledge in computer qualification and knowledge in counseling skills. That is no problem. My lord, we qualified in all these aspects and therefore we were selected and serving till date, my lord. Subsequently, what happened, my lord? A new advertisement comes up, my lord. That is at Annexure 5 at page 103, my lord. Page 103. This is, my lord. There are so many posts have been advertised, my lord. Our part is at page 106, my lord. At 106, relevant portion, my lord. The post we are aspirant, my lord, that is District Child Protection Officer. And presently we are holding the post, my lord, that is Protection Officer, which is at page 107. Has your lordship got it? We are presently in the post of Protection Officer since 2015-16. We were appointed at the point of time initially. And now this post has been advertised after so many years, my lord, DCPO. Since, my lord, our service is, my lord, contractual in nature, therefore there is no question of getting this post by virtue of promotion, my lord. So all we can get by competing in the selection process, my lord. Therefore, my lord, we applied. And then the question came up. Lordship may recall just before some time, 2 matters for withdrawal were mentioned, my lord. Age bar was imposed, my lord. That was challenged before your lordship. And then all of a sudden government said that no, we are relaxing. That hurdle we overcome. Now the second hurdle came up, my lord. My lord, may kindly see the eligibility criteria at page 106, my lord. Postgraduate degree in social work, stroke sociology, stroke child development, human rights, public administration, psychology, psychiatry, law, public health, community resource management from a recognized university. This is the academic part, my lord. The second part is, my lord, at least 3 years of experience of working with the government, non-government organization in documentation, training, capacity building, project formulation, implementation, monitoring, and supervision, preferably in the field of women and child development, social welfare. The Women and Child Department was earlier, it was Social Welfare Department. Now it has been renamed as Women and Child Department. So we were, my lord, we are working since 9 years. At that point of time, in the view of the same department, we qualify for the post. Now, my lord, they have rejected us on the ground that because we hold master degree in home science, like petitioner number 1 and 2 in home science, petitioner number 3 in anthropology. They says this anthropology and home science, these particular terms are not present in the eligibility criteria. Now they want to say this. The rejection, lordship can find starts at page 112, my lord. And our relevant portion is page 121. That is petitioner given. Petitioner number 3, Plavita Das. Reason of rejection in the serial number 1325, my lord. 1325. At the bottom of the page, my lord.
Petition number?
Plavita Das. Petitioner number 3. The reason of rejection in the right-hand side column, my lord, MA anthropology. So I have been rejected because I am MA anthropology.
Oh.
I will explain it how an anthropology is, my lord, relevant to our case. And next is, my lord, page 123. Serial number, my lord, 6216 begins with 6216, my lord. 6216 serial number. That is petitioner number 2, Dipanjali Devi. Next one is, my lord, 6349, Pritimani Gogoi. That is petitioner number 1. 6349. That is petitioner number 1, Dr. Pritimani Gogoi. The reason of rejection in both cases, my lord, MSc Home Science. Lastly, my lord, serial number 4515, my lord, bottom of the page, my lord, same page, bottom of the same page, 4515. Actually, this is not the serial number. These are the, my lord, IDs of their applications. 4515. Prostuti Bhuya, this is petitioner number 4. Reason of rejection, postgraduate diploma in management. So these are the reason of our rejection. Now the ground of the petitioners, my lord. Again, we come back to page 106, my lord. The qualification criteria prescribed. This qualification criteria has been prescribed in terms of the operational guidelines of the scheme. There is no doubt about it. Operational guideline of the scheme. There is an operational guideline that is at annexer page 84. Starts with sorry, madam, not 84. It is 25. Page 25. Starts with page 26. And our part is at page 88, my lord. 88, selection process guideline. Page 88, my lord. So we will read the qualification criteria from page 88, my lord. Instead of 106, we will read it from 189. Page 89. Have your lordship got it?
Yes.
Yes. My lord, the district child protection officer. This is the post we are aspirant of. The postgraduate degree in social work, sociology, child development, human rights, public administration, psychology, psychiatry, law, public health, community. Department says home science is not a identical course to this. Anthropology is not a identical course to this, because these two subjects are not specifically mentioned in this guideline. But our case is that, my lord, these are identical course. If, my lord, department consults with the APSC, they will know, my lord, this home science is the, my lord, home science includes all these things, my lord, all these subjects. It is the most vast course, my lord. And anthropology also includes sociology and all these things, child development, all these things. That is why, my lord, in APSC courses, in APSC examinations, my lord, anthropology and sociology are never allowed to be taken together, my lord. Two subjects are required to be selected, my lord. These two subjects are never been allowed to take together, my lord, select together. Lordship may now kindly come to page APSC 2%. Page 163, my lord. This is the APSC, my lord, advertisement. Page number 162. And then page number 163 is the relevant portion. 162. Page number 162, have you lordship got it? This is, lordship may kindly see the post, Child Development Project Officer. These are the regular posts, and therefore it has been advertised through APSC, my lord. And our post is, since it is a contractual post, my lord, therefore it has been advertised by the directorate, my lord. This is the only difference, my lord. The nature of work, nature of responsibility, everything is same. Lordship may kindly see the qualification criteria has prescribed at page 163, my lord. page 163. Lordship has got it. Graduate in arts, science, commerce, having philosophy, education with psychology, economics from a recognized university, my lord. Number 2, graduate in arts, science, commerce, and postgraduate degree in diploma in social works, labor and social welfare, sociology, anthropology, criminology from a recognized university. Number 3, my lord, graduate in child development, home science, nutrition from a recognized university. So home science, anthropology, sociology, all are there, my lord. Department is maintaining these norms, my lord. In respect of the regular post, home science, anthropology, management, everything is there, my lord. And in our case, my lord, no, you cannot. Because why? These two terms are not specifically mentioned in the guideline. Then what is the application of your mind, my lord? We were selected initially on the basis of these qualifications presently we are holding, my lord. Possessing, my lord. And we have been in the service since last 10, 12 years, my lord. So if we go to the experience part, qualification, minimum 3 years, we have 5 times more experience, my lord. So this is our case, my lord. One more aspect I will draw your attention of your lordship, my lord. At page 160.
When was the reject list issued?
On 17th, my lord, it was published in the official website. That I will explain it. There are some other things there, my lord, connected. On 17th, my lord, the select list and the reject list was published in the official website. Somehow we could get it by 18th in the morning, and then immediately we rushed to court. Why? I will come to it, my lord, later on, my lord. Now, lordship may kindly turn to page 160. We have a clear statement in the repetition, my lord, because within short span of time, my lord, we could not collect all the documents, though we have filed RTI applications. Even then also, my lord, from our personal knowledge, I will point out serial number 20, one Poppy Das appears there, my lord, at page 160. Lordship got it? One Poppy Das, serial number 20. We have clear statement in the repetition, my lord. Poppy Das, as far we know, my lord, is the economic background and management background, my lord. She has been categorized. By now we have got information, my lord. There are so many other graduates, my lord, who have been selected.
This is a select list.
Yes, this is a part of select list. Page 160 is a part of select list. Select list starts from, my lord, page 131. Select list starts from page 131 and relevant portion in our case is page 160. We are referring to, my lord, one candidate, Poppy Das. My lord, this reference we are making, we have no any grudge against that candidate. We don't want to challenge her selection, my lord, in the list, but we are referring it because to make out our case. We want to say that why discrimination?
When is the selection?
On 25th, my lord, examination. Therefore, my lord, without the entire documents, because it was not possible for us to collect all the documents of all qualifications of other candidates who were selected. So we directly came to this court in time, my lord, because the examination is fixed on 25th. If the examination goes, my lord, it will be a lifetime deprivation for us, because then again age bar will come up in case next advertisement age bar will come up, my lord.
Yes,
Apparently, my lord, they know what their status, my lord. They are appointed on a contractual basis. Now, this qualification prescribed as per guidelines. We cannot deviate it, my lord. So, petitioner, they does not possess this, my lord, qualification. Definitely, my lord, they are not qualified. Regarding age relaxation, that is a provision in the state government employee, those who are working.
age relaxation, you have done it.
Different.
We have corrected. Now, qualification, we cannot correct it because
But then what about page 160?
160, I don't know, my lord. Cannot read it, my lord. This page, I cannot read it, my lord. What is this?
Poppy Das boli ache.
Poppy Das boli kole hobe na, how can I read it? I cannot read it. But this is cannot be a make reference, my lord. It is different thing. So petition of qualification does not match with the advertisement. They is not eligible. Other person are also there. Similarly, those person are, they are not having this qualification, they are not applied. So if the petitioner is allowed, then it is a violation of Article 14, 16, my lord. Other person is
No,
not.
no. What they're saying is other persons also without the qualification are allowed,
No, my lord.
are in the shortlist.
No, my
Correct.
lord.
Yes.
Not, I cannot, my lord, agree because I cannot read it also. What is the enacted, my lord, whatever may
No,
be.
it's not a question of whether you agree or not. It is a question of whether what the petitioners are alleging is correct or not.
No, petitioner rejection is correct because
Petitioner rejection is correct, but about the shortlist candidate,
no, it is not shortlisted by us, my lord. This is not shortlisted, my lord.
who shortlisted this?
By the respondent number 3, my lord, same person.
Director.
Director, my lord.
Copy that, my lord. No, they are not making Popidas as a party, my lord.
No.
How can they will answer? If they should answer whether she has possessed this qualification or not, how they know what is the qualification of the Popidas? They are saying that their knowledge. It is not, my lord, sufficient to, my lord, establish their case. So far this rejection is concerned, lordship kindly see page 121. Plavita Das. Apparently she MA anthropology. MA anthropology, how it can be matched with the advertisement. Advertisement say qualification, lordship, my lord. This is the postgraduate.
That I've seen.
Yeah, postgraduate degree necessary in
Why
the
don't you take instructions and come back? Tomorrow we'll take up.
tomorrow, my lord.
Hmm.
Along with this order, we have mentioned it, my lord.
Along with?
We mentioned 6252 2023. I will obtain instruction regarding Popidas, madam.
No, 6252, what you have?
We just mentioned similar matter he filed. They are the petitioner.
Hmm.
The age relaxation. It may not be, my lord,
That I think has become infectious,
infrastructure.
isn't that?
Yes, tomorrow morning, my lord.
Okay, Kurt,
My
Mr.
lord, is my learned senior will obtain instruction regarding Popidas and whether other some candidates has been enlisted, my lord, having other qualifications not specifically mentioned in the criteria, my lord, not specifically mentioned in the guideline. That will he
No,
do,
my
my
lord,
lord.
that
And, my lord,
instruction is not necessary because he is to establish his own case, my lord.
as I have shown in the, my lord, APSC advertisement, my lord, same department, same nature of work.
Okay, Kurt, Mr.
M. Fukundan.
M. Fukandan, Council for Petition. Mr. T.C. Chutia, the additional senior governor, shall take instructions as to whether the person, namely Bobitas, with ID number 20, within bracket, page 160 to the writ petition, has the qualification prescribed in the advertisement for the post of
District Child Protection.
District Child Protection Officer. So, please, the matter again, tomorrow is what date? 23rd.
Much older.
Obliged.
Anybody appearing for the central government?
Central government, my lord, I don't know.
Government.
Have you served copy?
Yes, yes, sir. Much older.
Item 1 of daily list, part or admission method.
May I please your lordship?
Hmm.
Lordship, I am for Mr. P. Nayak,
Hmm.
the Learned Standing Council for BTC. Unfortunately, lordship, he is not present today due to some personal circumstance. So we have already taken the consent of the petitioner. So your lordship may kindly adjourn the matter for today.
When do you want?
Lordship, on 5th of March preferably.
Fifth, we'll have it on 12th March.
Lordship,
On request made on behalf of Mr. P. Nayak, Learned Standing Council,
BTC.
BTC, list the matter on 12th March as part.
Lordship, obliged.
To
The last occasion, on 7/11/2022, 22/11/2022, and 9/1/2022, the information was sought from the respondent whether So the termination order was dispatched and communicated to the petitioner or not? Have you filed your affidavit? Lordship, that affidavit, I have already made a statement in my pleading that I have not received it. I saw it at para 9. No, the order of 6/2/2024 says
Yes,
that the counsel for petitioners, he wants to file an affidavit to bring on record certain facts.
yes, yes. That fact, Lordship, what I wanted to bring in, that a termination order was not received by me and received by me after my retirement. So my detachment from service was not by termination but by retirement. But whether it was dispatched by the petitioner, that is my point. Whether it was dispatched by petitioner before my date of retirement, because on the last day of my service, I was terminated. On 31/5/2014, I was about to retire. On 30/5/2014, I was terminated. If they have kept in their file and not dispatched it, then that point I can raise, because then it is not a legally valid termination order. So whether it was dispatched by the petitioner before the date of my retirement, that they can only. Lordship, otherwise the affidavit is also ready to file. Lordship, moreover, I was terminated without any disciplinary proceeding.
Your Lordship, the records are here. And Your Lordship may just have a look. There was a public notice at page 51.
Which?
Page 51 of my affidavit in opposition. The same termination, Your Lordship got it, page 51.
Yes.
Page 51, this is the published in the Assam Tribune on 31
No,
2014.
Something is wrong. This annexure 2, is it?
No. Affidavit in opposition.
Oh, I'm on your affidavit in opposition. Is it the running page 51 or the
Internal page. Page 51.
51 74 নেকি?
এতিয়া কিমান হ'ব?
74
Yeah, running page will be 74, Your Lordship.
73?
73.
Yes.
Page 50 is the termination order. Then page 51 is the publication in the newspaper, Assam Tribune, that was done on 31/5/2014. The date is mentioned below.
Yes.
We have published this notice. It has gone out from my hand. The proposition of law which my friend wants to propagate is that an order issued but written in the file, unless it is communicated, it is not binding on the person against whom the order has been issued. The Supreme Court has said that once it goes out from my thing, that I cannot change the order, the date of receipt of the order is of no consequence. Here on 31/5/2014, I have already published that order in a newspaper, dispatched by speed post to his address, last known address, was on 4/6/2014. Dispatch was
You retired on 35.
35. Therefore, that is my point. It was kept in the file. I retired on 31/5/2014. It was dispatched from their office on 4/6/2014. That is after my retirement.
But it was published in the newspaper
there are
on
several-
31/5/2014.
Lordship,
I have not changed the order. I have not done anything. Once it is published, it's brought in, duly notified, his thing. Dispatch will not give him any.
So now they've said they've dispatched on 4/6.
4/6.
4/6/2014. Now you file your affidavit?
Yes,
Okay.
yes, Lordship, it is already ready. Lordship, I am not getting my pension. Lordship will fix a date. Lordship, I'll file it today itself.
Okay, Mr. B.B. Bora, then the counsel for the petitioner, so please, that we will be filing the affidavit as permitted on 6/2/2024, within the course of the day.
Within the course of the day.
When do you want?
Lordship may fix any date, hearing date.
12th of March, can it be, Your Lordship?
12th of March will be.
No, no, I'm not there.
12th of March at Manipur.
Manipur. 13th
13th
of March.
13th hearing date.
13 is not a hearing day.
Wednesday, Tuesday, knowledge.
You want a hearing day, we can have it on
yeah.
14.
14.
14.
14, Your Lordship, I will be traveling.
Oh, ठीक है.
Let it be on 13, Your Lordship, because
13.
13th of.
4 and 5.
May I please, Your Lordship?
Yes.
Your Lordship, on behalf of PJ Pukan, Standing Counsel, Guwahati University. Your Lordship, Senior Counsel is on legs in court number 23, so I pray for a short passover.
Passover.
I can start in the meantime, he can come, because I'll also have to place the facts.
Let him come.
Okay, ma'am.
I'll wait.
Highly obliged, Your Lordship.
7.
My Lordship may kindly refer the last order.
My please, Your Lordship, my senior, his legs in other court.
Who's your senior?
Dinath.
Senior Government Advocate. He is also in this case.
You're not here.
Yes, but he is in this case also. I'm here. I am for the government, he is for the ICS. No.
The institute as well as ICSS as well.
Yes.
You want it passed over?
For time being.
Typing.
Yes.
There are instructions to anything.
On the last date, my Lordship may kindly refer,
That I've seen.
the state was directed to produce, my lord, the order, whether that has been.
So who's supposed to come with the instruction?
Yes.
You or not?
No, but education department, what happened? Malad, they have written to me, Malad. Coast of Gogo is the senior state council education department. They said, they send the file to the Coast of Gogo. Coast of Gogo replied that there is no file at all. I have written to the Malad Transformation and Development Department. They said that we don't have this proposal because it is proposal for the education department. But education department, Malad, so far Coast of Gogo is concerned, he has written to me, Malad. I have not received any records.
So you want time?
That's why Lordship has given time, no problem, Malad. Otherwise, Malad, it is that was Malad while they passed the cabinet
Okay,
decision.
Mr.
T. Chakraborty, my lord.
Learned Counsel.
My lord, issue is that, my lord, some urgency on the part of the petitioner is there. My lord, before 29th, my lord, I want this may be fixed. My lord,
You are going to?
well, the issue is that is regarding age of superannuation. Petitioner is a professor under Amyo Kumar Das Institute. Lordship knows, my lord, the age of superannuation across professors has been raised to 65 years. But that is denied to the petitioner, my lord, on the ground that the petitioner is working in a research institute, not in an educational institute. And on 29th, my lord, he will attain the age of 60 years, my lord. Is his therefore, my lord, maybe on
That's why, Malad, the matter was ultimately, last occasion, it was a part heard matter in the court number 5. And 30th January 2004, matter was likely to be disposed of. The petitioner insists that court asked him to satisfy whether it is a educational institution or not. He did not satisfy. The court wanted to defer the matter because instead of dismissing the matter, defer the matter. He insists like that, my lord. He's going to be.
No, my lord, it was not
This
that.
court released the part heard matter on 30th January 2024.
Lordship will refer the order.
Lordship,
Order will
see-
speak for itself, my lord.
30th 1 2024.
This is apparently not a
So-
proper submission, my lord.
Lordship allow me to have instruction, Malad, why he is persisting that he will be retired. Let them retire. Court found Malad suitable, then court direct him. Malad.
Now, what about the record, my lord? They have been directed.
Record
to
is
They
the
will
cabinet.
produce the records.
Yes, my lord. They have not been
Even if
producing,
you-
my lord.
Even if you retire, we can put you back.
That observation, lordship may put.
No,
based
No,
on-
it's not required for any observation.
He's
That automatically comes. If you're successful,
yes.
you will go back.
But
If you're
otherwise,
not
that
if you're
again,
not
state will say, my lord, come with the plea that already he has been superannuated. There is no question, my lord. Otherwise, he is not eligible, my lord.
That's not the issue. If you are entitled to 65 years.
Yes.
You'll go back if you're successful. If you're not
Yeah,
entitled.
that is there,
the
madam, but-
matter is there.
Yes. But only that observation, my lord. But this observation will not affect anybody, my lord. If the petitioner fails, he will otherwise retire, my lord.
What observation is your,
That
that's
observation-
automatic, that's
My-
automatic.
Yes, it is there, but.
Then, what Mr. T. Chakravarti, learning counsel for the petitioner. Mr. On request made by Mr. K. C. Chutia. Then additional senior government. List the matter on when?
My lord, 27th, my lord. 29, my lord, because 29th is the last day, my lord.
Last day maybe, my lord, because working
That
day.
doesn't matter.
Today is 22 only. Their communication is going on, my lord. If I get it, I definitely put it. Actually, court wanted to see the proposal, but cabinet
Okay,
decision has.
on 29th to enable him to produce the reports.
Obliged, obliged.
10 ordered.
Lordship, I have received the instructions as per the order, Lordship. I'll file an affidavit.
Yes, my lord.
Why is it coming for orders? No?
My lord, mention was made, my lord, on earlier date, my lord.
No, not the question of mentioning. All respondents are complete. Notice?
Yes, my lord. Yes, my lord.
Why is it coming for orders?
Yes, my lord.
There's no office note, nothing.
The respondents are official respondents. I am for 2 to 7, health department.
You're for 2 to 7.
Yes, Lord.
Okay, heard, Mr.
SP does, my lord.
SP Das Standing Council for the petition. MS
G border.
D. Bora, the Standing Council Health and Family Welfare Department submits that she has received instructions and pays for
2 weeks time.
2 weeks time to file contract. List up to 2 weeks.
My date will be
Applied,
fixed,
sir.
my lord. This case is pending since 2017, my lord.
Around 23 matter.
No, my lord, if your lordship see at page 74, my lord,
Different
lordship's order is there.
The other cases of 23.
I kindly see, my lord, at page 74, my lord. Lordship's order, my lord, first order, my lord. 74, my lord.
It's 2017 matter, but that
Till
was,
then, my, from
that
that-
was disposed of, isn't it?
yes, my lord.
Oh, there.
What they did, my lord, they terminated me after my retirement, 6 years.
Okay, list down. Yes, 22nd. Okay. 14th March.
11 hearing.
Mr. K. Course, Senior Standing Counsel for PNID Department will appear in this matter. Lordship is actually is on the way due to the constructions going on in MG Road. He is stuck in traffic. Lordship, if possible, Lordship may fix it at 2.
Where's our petitioner's counsel?
Lordship, actually, on the last occasion also they were not present.
No. They were present.
Perhaps Mr. SP Sharma was there.
None appears for the petition. List after 2 weeks.
Very obliged.
13
May I please, your lordship? The case of the petitioner here is that he was appointed as the grade
Who is the respondents?
SC Health lordship.
That Vora was there, no? Can you just call her? Yes, Bora, you are in this matter?
No, lordship, in 13, I am not there, lordship.
Who's appearing?
It is lordship, DP Bora lordship. I'll inform lordship right now. After some time. Okay, lordship.
14.
Please, in the earlier occasion, this honorable court directed to produce report, record is ready. Matter pertain to dismissal from service, my lord, but petitioner was cashier cum clerk of the respondent bank, my lord. Kindly for the first time see the dismissal order, page 77. Sent to the letter then so in response to your written representative and regard to proposed funny, you have careful considered your submission in the background of the charges level against you, inquiry proceeding, connected papers, document, inquiry, etc. In view of the fact of the circumstance of the case, the gravity of the misconduct, and considering your prayer in respect of proposed punishment, I have again applied my mind and have come to the conclusion that proposed punishment commensurate with the gravity of the and therefore dismissed as per my lord, regulation 2010, my lord. Thereafter, my lord, I preferred appeal, my lord, before the my lord chairman, my lord, as per regulation, my lord. And
Yes.
and appeal, my lord, page 78, and the appellate authority thereafter, my lord, rejected my prayer, my lord, rejected my appeal, my lord, page 88. The appellate authority, while perusing the disciplinary authorities not opine that no new material has been placed and there is no merit for consideration of the appeal. And Kindly see, my lord, charge of allegation, my lord. Page 30, my lord. Annexure 4, article of charges, 3 charges framed, my lord. Alleging that, my lord, as 3 instruments, 3 check issued.
Read it.
But the article of charges during the tenure of service as clerk cum cashier at Assam Gramin Vikas Bank, Silchar branch for the period from 21/5/2005 to 24/5/2010, you failed to take all possible steps to ensure and protect the interest of the bank and discharge your duty with utmost integrity, honesty, devotion, and diligence, in as much as number 1, on 14/2/2009, you had deposited call deposit by 90,000 without any call deposit received under your user ID NLU as operator for credit to bank account Axis Bank and debited 1 at per check number 297324 sum drawn on Axis Bank favoring your account with UCO Bank Silchar, and thereby you have misappropriated the bank money. At second, my lord, on 21/7, you had also debited deposit suspense head by 96,332 in computer under your user ID NLU as operator for credit of bank check account check number so in your account with Eco Bank, and thereby you have appropriated bank money. No voucher was made for aforesaid tender with malified intent. And number 3, on 29/11/2008, you had deposited deposit suspend amount account for rupees 5,87,675 in computer under your user ID, the ID NLU operator to credit to bank check so against which voucher was prepared. Again on 20/11/2008, you had debited bank check account for rupees of 5,87,674 rupees. Vouchers prepared. Again on 20/11/2008, you had debited banker's check in computer user ID NLU as operator for credit to deposit suspend account, but on 26/2008, you had debited deposit suspend account for rupees 1 so in computer user ID NLU as operator credit bank Axis Bank obtaining as per check number your account with UCO Bank, and thereby you had misplaced bank account. Happened is that, my lord, 3 check issued by the, my lord,
Yes.
happened that, my lord, 3 check issued by the bank manager, my lord, and in the name of my accounts, my lord, and I am the, my lord, cashier, my lord. I also, my lord, operate the, my lord, process, my lord. But initially, my lord, that 3 checks issued by the bank manager, my lord. But no punishment or no defeat drawn, my lord, commonly, my lord, with the petitioner, my lord. And the respondent may initiate, my lord, separate departmental proceeding, my lord, against those person, my lord.
What is it?
My lord, the senior manager and manager, my lord. Also, my lord, my lord, respondent bank initiated the department proceeding separately, my lord, but not in common, my lord. As per regulation, my lord, there is a provision for common, my lord, departmental proceeding, my lord.
If you taken that ground into this petition,
My lord,
you have taken that ground.
lord. Common,
Where?
Page 16, paragraph 16, my lord. That the petitioner submits that from the circumstance narrated herein above, the crystal clear that the inquiry conducted against him was a French farce and it was no designed to make him a scapegoat in the matter towards protecting the higher up in the bank, right from the stage of holding separate inquiries against all the concerned in the case instead of joint and common inquiry proceeding as mandated under the rules and regulation of the bank to deny the opportunity meted out in the inquiry proceeding. My lord, for a moment, my lord. With the same charge framed, my lord, against the officer in different inquiry proceeding. And subsequently came to name, my lord, the departmental proceeding, my lord, the bank authority award punishment, my lord.
Into what is materials on record. My lord, some papers my learned friend will submit.
No,
And
that
they-
is what I was about to say.
Yes, my lord. They can take us by
Just-
surprise.
Just not on record, if you want to supplement all your arguments, you have to file by way of an additional affidavit. Otherwise, just passing on papers like this, especially in such a matter, it is not
My
proper.
lord. But it is, my lord, admittedly, my lord, admitted by the respondent bank, my lord, in his
So if you
affidavit, my
want
lord.
to, if you want to supplement your arguments
Well-
by way of these documents, you will have to file an affidavit.
Then, my lord, 1 week time may be granted, my lord. To file additional affidavit regarding that.
My lord, if they want to rely it, my lord, we have the right to counter also. Because this is not the legal position. my lord.
Okay.
The inquiry, full-fledged inquiry was held. They have swallowed that amount, my lord. It's admittedly, my lord, and in their written statement, they have accepted all that. They have returned that amount.
Mr. K. Patkari, and the council for petition. Place for filing an additional affidavit. To place some relevant documents for the court. There is a lot, list after 1 week,
1 week.
Mr. Patkari.
That may be fixed, my lord.
Mr. S. Datta, and the council for the respondent bank.
My lord.
Much obliged.
Item
15.
Please, Lordship. Passover matter for a time being, Lordship. RKD deputy election another court, Lordship. He has just informed me, Lordship. 15 and 16, Lordship. Kindly pass over time being. 16,
15.
16 is also. Okay, you want time, Lordship. For time being. For time being.
for the time being.
Seventeen.
Lordship, I appear for respondent number 4, 5, and 8. Lordship, the counsel for the respondent, these respondents, Mr. M.K. Chaudhary, as well as counsel for the petitioner is on late, my lord. My lord, today there will be some difficulties because there are other matters. Matter may be passed over for the day, my lord. And there is a clear
The joint request is a joint request.
joint request. And counsel for the petitioners also prayed that if convenient, the matter may be fixed on my lord 7th of March.
7th will be difficult. Some difficulty is there on the part.
Any day, my lord. Congratulations.
Okay, on request made by the parties. List the matter on 14th.
My lord. Now, is it possible little earlier, my lord? If possible.
12th also I fixed quite a lot of cases. It will be 14th.
My lord.
Eighteen. Eighteen.
We have already filed affidavit.
You have the records.
Record is, yeah, keep record.
Hmm?
Petition, nobody is repairing.
Have you got the records?
I have got it.
You've got the record.
That will be fixed, my lord, I will post.
No, no, please for the petition. Sufficient to give them additions. You have for respondents, all respondents.
All the respondents.
All respondents. You want a date fix?
Yes, first week of March, my lord.
19th.
Obliged, my lord.
19.
Wait, please, your lordship. Lordship, I'm for the respondent blank. Your lordship, in the morning, I'm informed by the petitioner that she is having some health issues due to which she will be unable to come to court today. The matter may kindly be adjourned on her behalf. Your
Who's the petitioner's counsel?
lordship, some F. Begum.
SK Ghosh.
Yes, yes, your lordship, SK Ghosh.
On request made on behalf of SK Ghosh, then the counsel for the petition. Next the matter after 2 weeks.
Obliged.
20.
Please, your lordship. Appear on behalf of the respondent number 2, 3, and 4.
Lordship, P.K. Munir is out of station, my lord. I couldn't make the mention in the morning, my lord. So, my lord, matter may be adjourned for that. I have given the request, adjournment request. Extra.
My lord, it is fixed from earlier and I have come from outstation, my lord.
An adjournment request was circulated yesterday. I think.
I have given,
You've taken the consent.
yes, my lord. From respondent number 2.
I am 2 people.
Yeah. DB Bora.
My lord, in that event, would your lordship's pleasure would be to fix the matter on 7th.
7th will be difficult.
Then 14th with some precedent in the matter in the upper side. Because my lord, we are suffering an
On
interim order,
request
my
made
lord.
on behalf of Mr. P.K. Munir and the counsel for the petitioner, this the matter on 14th.
14th, my lord.
14th March.
March,
Number 1.
MS K. Fukan
Would your lordship
SK
kindly
appears for
be
the
pleased to
respondent
record
number
my name also, because I am not the recorded advocate, but I am the counsel.
and Mr.
A. Chakraborty.
A. Chakravarti and the counsel appears for respondents 2, 3 and
4.
Much obliged, my lord.
just call out. Let's see if another will adjourn the matter.
Four and 5. 4 and 5.
May it please your lordship. My senior is on the way.
What can I do? The Vote is over.
Wait, please, Your Worship.
Barwa, the others counsel is not here.
He's there, my lord. He's outside. I've just sent my junior to fetch him. He'll come.
Who the counsel?
PJ Fukon, my lord. He's there outside. I've sent my friend to fetch him, my lord. My lord, on 17/4/2012, my lord.
17 for
17/4/2012, my lord. An advertisement was issued for various posts.
Fukan, you are ready?
Lord, maybe adjourn for the time being, my lord.
Huh?
Half an hour, my lord.
The vote is complete. Now I'm just going over the.
Then, my lord, he can start.
Page number 18, my
You
lord.
are ready for arguments today.
Lord, and IA is also there, my lord.
Oh,
My lord,
IA is for stay vacation.
that's
And
a different.
my lord, the matter may come up on Monday, my lord. It will be better, my lord, along with the IA.
IA has already come, my lord.
I yes, listed.
It is already there in the list.
Matter may come up on Monday, my lord. It will be better.
Well, the problem is, my lord, although there is a stay order protecting me, they are not complying with the order.
You better comply.
That is the
Your,
biggest
uh,
difficulty.
He is a contractual employee. His term is over long back, my lord.
Okay. Then, we'll take up on Monday then.
Or let it be on a hearing day, my lord, 27th.
But Mr. A.K. Barwal and the counsel for the petitioner on request made by Mr. P. Fukan and the standing counsel party would proceed. Please, on, when do you want?
27.
Obliged, most obliged.
13 hearing.
Any date may be given.
But MS U Nandal and the counsel for the petition. None appears for the respondents. None appears for the health department. Of. List, when do you want?
29th. Much obliged.
15.
The 15 and 16, my lord, they said for the time being, my lord, the R.K. Dev Chaudhary, in the both the cases, he is appearing. My lord, may I pray, this matters may be taken away too, my lord, subject to convenience, my lord, because it will not take so much of time. And same issue, lordship has already decided, my lord, and that judgment I will be placing. My lord, it's a dismissal from service on the ground of unauthorized absence. In a case of unauthorized absence, my lord, the search and the inquiry should be to the effect that he is unauthorized absence willful. Those are lacking here. And a brief argument will be made, my lord. So add 2, my lord.
Yeah, Patkari,
My lord, another date may be fixed, my lord.
okay. But Mr. K. Patkari and the counsel for the petition. None appears for the respondents. List again on, when do you want?
Lord,
March,
March, my lord.
14 March?
My lord.
Okay.
Obliged. May I please?
You- Yes.
Lordship, I beg apology, Lordship. In item number 1, Lordship,
Hmm.
in the morning, Learned Counsel for the BTC has mentioned this matter, Lordship, and fix it on 12th of March, Lordship.
Hmm.
Lordship, can it be taken up on 11th of March, Lordship? Yes, partner.
Then,
I will inform him, my lord.
okay. Report should be required.
My lord, I have placed everything, inquiry report and all, my lord. These are there,
That would be sufficient.
Let us see.
my lord. My lord, here, my lord, before I start, my lord, the writ petition initially was dismissed. This writ petition, my lord,
Hmm.
by order dated 17/3/2022, my lord. Judgment and order, my lord. 17/3/2022. Whereby, my lord, para 15 of the judgment, my lord, the honorable court said that, my lord, while exercising article, power under article 226, my lord, as per these two judgments, if there is inquiry and on the basis of inquiry that the punishment imposed, court does not have the power for going ahead or to say that the punishment is bad. My lord, this order was challenged before the honorable division bench, my lord. The honorable division bench in writ table number 164, perhaps the judgment is there, or I will, my lord, sir, pass on one copy, my lord. 164, my lord. Writ table number 164, 2022, my lord. Dagmara to Diluni. My lord, the honor,
1 minute.
my lord. .
Yes.
Yes,
Read April 164.
yes, my lord. It's basically para 9, my lord, of the judgment. Here it is said because the case is of unauthorized absence and the punishment of dismissal from service. So in such cases, my lord, the Honorable Division Bench para 9 said, my lord, at the very outset, we may note that there is inherent lack of phraseology willful absence in the article of charges, as well as the order imposing penalty. The patent ground spell out from the prediction the writ petition is that there was no allegation against the appellant writ petition of being willful absent from duty. In this regard, we like to refer to the affirmations made in paragraph 17 of the writ petition. I have taken that ground there. Their argument was, my lord, that I have not taken that ground. The arguments were raised before the learned single judge, which has been taken note in paragraph 13 of the impugned judgment, but in contrary of finding at paragraph 14 of the impugned judgment, the learned single judge observed that the petitioner has not made challenge to the dismissal order on the ground of procedural irregularity. The observation appearing in para 13 and 14 of the impugned judgment inconsistent to each other. In such view of the matter, my lord, the writ appeal was allowed. However, my lord, this writ petition was remanded back for fresh adjudication. Therefore, my lord, this matter has come up for hearing once again, my lord. Now, all the facts in this present case is that, my lord, he was page 18, my lord. The petitioner was appointed as constable in CRPF, my lord, 21/1/2007, lordship. Page 18, my lord. 21/1/2007. My lord, thereafter, I beg to lordship attention at para 4 of the writ petition. My lord, in the meantime, he was posted in various places, para 4, my lord. But while he was posted in Delhi, my lord, he met with an accident on 22/12/2009. And he suffered head injury and his right eye. My lord, for that, the authority, my lord, page 20 of the writ petition again, my lord, from the annexer, they have granted leave. This head injury led to, my lord, mental imbalance. Now he is fit and fine. However, my lord, this unauthorized absence, my lord, kindly see page 20 of the writ petition. He received injury on 22/12, and this is the order. It is inform you that you were proceeded on 30 days on leave. He took on leave after the accident, my lord.
When did the accident occur?
Accident on 22/12, my lord, 2009. And on leave for the period, my lord, 6/1/2010 to 4/2/2010. Because his head injury aggravated, my lord. From 6/1/2010 to 4/2/2010, my lord. This was the 30 days leave they allowed, my lord. This is para I am reading. It is informed that you were proceeded 30 days on leave with effect from 6/1/2010 to 4/2/2010. With direction to report back rejoin duty on 4/2/2010. He was supposed to join on, my lord, 4/2/2010. At your own, without permission from the competent authority. But you have failed to do and remain overstaying from leave with effect from 5/2/2010. My lord, I am showing this document because 30 days initially, while he was out from duty, my lord, he was given leave to show that, my lord, for limited purpose. And therefore, second notice was issued to report back on duty, page 21, my lord, annexer 4. This is similar nature of notice asking him to report back on. He could not report back.
Why? My lord, because, my lord, did you receive this letter? Yes, my lord. Yes, I have annexed, I have received. Because, my lord, I have stated that his parents, my lord, given him medical aid because his parents took back him from Delhi. And he is a person from Nalbari, Assam. He was given treatment locally and thereafter this aggravated and later on, my lord, he was treated in Tezpur Mental Health. Although this certificate is subsequent, but head injury for which his mental imbalance occurred, and this is the reason for which he was given treatment in mental health Tezpur, my lord. That, however, I admit these two documents, certificates, is of 10-14 days after the issuance of the discipline punishment order. I will show that, my lord. To say, my lord, or to give a appreciation of the fact that for the injury suffered, my lord, he received mental, my lord, head injury, which led to mental health condition deteriorated, and he was admitted in mental health college hospital, my lord, in Tezpur. Now, my lord, lordship now directly come to, my lord, the article of search. They sought for an inquiry. So after this disciplinary proceeding was. Yes, yes. And in fact, before that, a page, no, Hari.
Subject to correction.
Page 28, my lord.
The certificate issued by the mental health authority is later.
I have said that.
Is later.
I said. My lord,
I address your lordship on.
yes, yes. Page 28, this is the my lord, the proceeding initiated to declare him deserter. Page 28. I have challenged this also. This is behind my back. No inquiry report, nothing was given to me as per the judgment of my lord Ramzan Khan and all. And subsequent thereto, my lord, page 30, this is the inquiry for imposing punishment under Rule 27, my lord, of CRPF Rule 1955. Now, article of search, my lord, statement of allegation is at page 31. My lord, the said number so and so constable general duty GD Pankaj Besbarua, while functioning as so and so Mahabir Nagar campus, Delhi, has committed an act of misconduct in his capacity as a member of the force under section 11(1) of CRPF Act 1949. In that he deserted from colonial line on 4/10/2010. Allegation from my lord, 4/10/2010 he deserted and still absconding. My lord, this is the article of search. Now, for a moment, if lordship looks into that CRPF Act, my lord, for the purpose of section 11(1), yes, my lord, section 11, my lord. 49, my lord. Major punishment, my lord. Section 11, my lord.
Minor punishment. 11.
Sorry, minor punishment. This is 11(1) that they have referred. 11(1) it states, my lord, the commandant or any other authority officer as may be prescribed may subject to any rule made under this act award in lieu of or addition, suspension, dismissal or any one of the following punishment to any member of force where he considered to be guilty of disobedience, neglect on duty, on reminiscence in discharge of duty or other misconduct. Malad, that is not itself is a misconduct. This is punishment for misconduct. But the article of search, they say this is misconduct under 11(1). That is wrong, my lord. in my humble submission. Misconduct, my lord, for absence in duty, 10M, my lord, of the section, my lord. Section 10M. Absence himself without leave or without sufficient cause or overstays, leave granted or not. Here, leave granted. Just for argument's sake, my lord, I wanted to point it out there. Now, my lord, the inquiry report, lordship, I could not attend the inquiry because I was on mental imbalance. And they conducted the inquiry behind my back. However, they say that they, on a particular occasion, I appeared before in their office, and on that date, my lord, they have handed over me the memorandum search. And my lord, from the inquiry report, page 38, this is my statement they have recorded, my lord. Analysis of evidence obtained. Page 38, my lord. On analysis of evidence, it is found that there is no information as to why so-and-so Pankaj Besbarua had absconded from the campus line and how. Whereas, on the basis of statement of Constable Pankaj Besbarua, it is learned that as he did not know anything as to what happened to him due to his mental stress illness, he absconded, but he has no proof that he had suffered from mental illness or stress. During his disappearance, he did not make any communication with the company or the force, though appeared before the investigating officer at the preliminary stage of investigation after he had been served notice to that effect. But on 19/7/2011, he again absconded. Before completion of the investigation in this way, Constable Pankaj Besbarua has neglected the duty. The order violated the discipline by absconding from the force. Now, finding, my lord, on perusal of the documents and statements of the witness, the following findings emerged from the investigation. Oh, it will be skill. Findings. Explanation. The allegation against 7. The allegation against Constable Pankaj Besbarua is that absconded from the line without permission on 14/10/2010. An FIR was lodged in this regard, and when a complaint is filed, the company officer a warrant of arrest was issued. Therefore, despite that, Constable Pankaj Besbarua did not return to force and remain absconded. In this way, Constable Besbarua has disobeyed and neglected the duty. Now, my lord, from finding of investigation, lordship, second para of this paragraph, my lord, on the basis of witness number 1, 2, and 3, lordship found, my lord, the Constable Pankaj Besbarua was found to be obedient to his duty, but no information could be found as to why he had absconded. As per the version of the accused, he absconded and remained absconded owing to his mental stress or illness. That means you joined in the departmental proceeding, isn't that? You participated in the.
Yes, my lord. Yes, my lord. Actually, my lord, he went to my lord, join the duty on, my lord, 1/7/2011, and he was allowed to be there in the, my lord, force up to 19/7/2011. And 19/7, they have taken the statement of the, my lord, petitioner, and thereafter they have not allowed him to continue there. My lord, because no.
That is an incorrect
No,
statement.
no, I will show from the record.
That we have not allowed him.
Mm.
He absconded lordship again.
No.
He was not there. That is why he did not even complete the inquiry.
No.
It's a wrong statement, lordship. I seriously object.
Yes.
That we did not.
Now, my lord, the thing is that in any case, he went there and his statement recorded thereafter. So for the purpose of inquiry, he has gone there and he will not be there. My lord, I do not know why the reason after 1907, 2011. In any case, my lord, now the suggestion, lordship, see page 40, suggestion of the inquiry officer. From the statement of accused and other documents submitted in connection with the search level against so-and-so, as the accused appeared before IO and had been served the notice by the IO, but again absconded before the completion of investigation, it seems that Besborua does not want to rejoin in the force, but he voluntarily went on 1/7/2011. He voluntarily went to the unit, my lord, on 1/7/2011, page 49. Their disciplinary order I will show, my lord. They have stated. Now, my lord, from these two documents, from the article of search as well as the inquiry, my lord, lordship, my argument based to the point that, my lord, while there is an inquiry for unauthorized absence, the inquiry must to be to the allegation should be to the effect that your absence is your unauthorized absence is willful. In the statement of allegation as well as, my lord, the departmental inquiry they have conducted, there is no finding to that effect that willfully you have out of your duty. Therefore, why punishment should not be given? So, while I challenge the earlier judgment, the Honorable Division Bench has also come to that conclusion that there is a clear procedure irregularity with the, my lord, departmental inquiry, because they have never said, or in fact their search is also not to that effect that you are willfully out of the job.
Where is that in the division bench? order?
Yes, yes. My lord, retapil, my lord, just I place, my lord. Once this is the same case here, my lord, after dismissal. Uh, 164, my lord. Now, lordship, it will be very clear if I read para 6, my lord. Mr. The learned counsel representing the appellant urged the specific argument was advanced before the learned single judge that neither the article of search stated the absence of the appellant from duty was willful, nor did the inquiry officer concluded so against the appellant. He further submits that even the disciplinary authority, while passing the order of dismissal from service, did not hold the appellant responsible for willful absence from duty. Moreover, disciplinary authority did not record any specific finding as to whether the appellant herein was responsible for more heinous offense as defined under Section 9 of Central Reserve Police Force Act 1949 or less heinous offense as defined under Section 10 of the said act. Thus, it was the fervent contention of the appellant's counsel based on the Honorable Supreme Court judgment in the case of Kushan B. Perma versus Union of India, 2012 3 SSC 174, Union of India, another judgment, civil appeal number 4059, decided on so and so. That penalty of dismissal of service imposed upon the appellant was totally unwarranted, unduly harsh, disproportionate, and unjustified. He thus implored that the court to accept this appeal, reverse the impugned judgment and order passed by the single judge, learned single judge, was the same as a consequence, was reverse the order imposing penalty of dismissal of service upon the appellant. Now, par contra his submission, my lord, the respondents of para 7, Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, vehemently and fervently opposed the submission advanced by the appellant's counsel. He argues that no such argument ever advanced on behalf of the appellant, who were learned single judge, and that impugned proceeding suffered from any procedural defect or irregularities. His assertion was that even the argument lack of finding regarding allegation of willful absence from duty was not advanced on behalf of the appellant before the learned single judge. He submitted that the only challenge which was laid before the appellant, the reed court, was based on flimsy, therefore, that the appellant representative was suffering from mental ailment. He does urge that the impugned judgment is based on an opposite appreciation of materials or evidence on record and does not warrant interference. We have heard. Now, my lord, para 9, my lord. At the outset, this is the Honorable Court finding, my lord. We may note that there is inherent lack of phraseology, willful absence in the article of search, as well as the order imposing penalty. The patent ground spell out from the pleadings of the writ petition is that there was no allegation against the appellant writ petition of being willful absence from duty. In this regard, we'd like to refer the amendments made in para 17 of the writ petition. I've taken the ground willful absence, my lord, that para 17. The government said, no, he has not taken that ground. This is wrong, my lord. This argument was raised before a single judge, which has been taken note at para 13 of the impugned judgment, but in a contradictory finding at para 14 impugned judgment, the learned single judge observed that the petitioner has not made challenge to the dismissal order on the ground of procedural irregularities. The observations appearing in para 13 and 14 of the impugned judgment are inconsistent to each other. Now, my lord, so far is judgment, so Kusumabi Parmar. Let me place the judgment, my lord, because after the inquiry, they have dismissed me from service without ascertaining whether my absence was willful or not. There is nothing in the article of search, nor in the inquiry report and the disciplinary order, my lord.
Of willful absence.
Yes, nothing on there, my lord, that my absence was willful. Now, my lord, lordship had, may kindly recollect one judgment lordship passed. Okay, first, my lord, Kusanbi Parmar, this is a small paragraph.
2012.
2012, my lord. Paragraph 16, 17, 18, and 19. I may read from para 19, my lord. 17, I'm sorry. 17, 18, and 19. In absence of, if the absence is the result of compelling circumstances under which it was not possible to report perform duty, such absence cannot be held to be willful. A absence from duty without any application or prior permission may amount to unauthorized absence. It is maybe an unauthorized absence, my lord, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, the employee cannot be held guilty of failure of devotion to duty of behavior unbecoming of government servant. In a departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In absence of such finding, the absence will not amount to misconduct. In present case, the inquiry officer on appreciation of evidence, though held that the appellant was unauthorized absence from duty, but failed to hold that the absence was willful. The disciplinary authority, as also the appellate authority, failed to appreciate the same and wrongfully held the appellant was guilty. My lord, therefore, by setting aside the impugned order, page paragraph 21 and 25, my lord, reinstated the appellant on, my lord, in duty with backways of 50%, my lord. Now, my lord, next judgment, my lord, small judgment, 2016 1 GLT 704, my lord. Here, my lord, para 11. Para 11, my lord, the basic search against the petitioner was that of unauthorized absence with effect from 28/4/2006. Para 11, my lord. From the documents placed on record, it appears the petitioner was suffering from depressive psychosis, a mental ailment, and was under treatment in Guwahati Medical College Hospital during that period. As per the medical certificate dated so-and-so, she was declared fit to resume duty only therefrom. As a matter of fact, petitioner had applied 83 days leave, which was in fact process in the Office of Disciplinary Authority. In Kusanbi Parmar, this judgment was followed, my lord. The Honorable Supreme Court held that the question as to whether unauthorized absence from duty amounts to failure, devotion to duty of misbehavior, unbecoming of government servant cannot be decided without deciding question as to whether absence is willful or because compelling circumstances. In this case also, my lord, that was not the SARS and willful was not even held by the inquiry officer as well as disciplinary authority. Therefore, my lord, the dismissal order was quashed and paragraph 16, my lord, reinstate back in service with 50% backways. My lord, next judgment, my lord, may recollect, lordship had passed these judgments, my lord. I had the occasion before lordship, appearing before lordship. Here also 414 days unauthorized absence, my lord. It is the CRPF. He was, the ground is also my lord same. Here Dharmeshwar Seal, this is Dharmeshwar Seal. WPC number 2799, lordship found that, my lord. 2799, 2017.
Yes.
My lord, here lordship has followed that Kusanbi Parmar at para 14. Para 17, 18, 19, lordship have quoted and lordship said that para 15, my lord. Coming back to the case in hand, already observed this court petitioner indeed under medical leave during the absence indicated issued in Nalbari. Therefore, this court is of the considered opinion that present is solely covered by the case of Kusanbi Parmar. This court does not find any intentional or willful act of petitioner from absent himself from duty. And thereby lordship had allowed this writ petition reinstate back in service with 50% backways. My lord, this judgment was put to challenge before the division bench of honorable court, my lord, in writ appeal number 52 of 2019.
50?
52 of 2019, lordship. And while admitting this appeal, my lord, the honorable only admitted the appeal for the purpose whether backways of 50% is correct or not. Otherwise, so far reinstatement, that part was not touched. He was in the interim, he was directed to reinstate in service. However, appeal was admitted whether the granting of 50% was justified or not. The honorable court, my lord, held by para 13, my lord, it's a long para, by referring to various judgments, that so far 50% backways, reinstatement with 50% backways is justified, and therefore challenge made
Para?
para 13, my lord. Just one more paragraph, my lord, of this judgment, para 12, my lord. That lordship
Of
just
division bench.
of division bench, that lordship judgment was upheld by this observation, my lord. In the present case, also disciplinary authority, while concluding in the charge of absence from duty against the responding employee, simply observed that delinquent officer was unauthorized, undisciplined worker
and his action tantamounted to an offense punishable under section so-and-so, read which so-and-so rule. The period of absence 414 days was treated as dice known and the penalty as aforesaid was handed down to the delinquent. There is no patent finding of the disciplinary authority in the order dated 15/1/2025 that absence of delinquent employee was willful. Thus, factual aspect of the case is squarely covered by the ratio of the judgment in the case of Kusanbi Parmar. And hence, the order of the single judge to extend the order of the removal from service was reversed and he was ordered to reinstated in service is fully justified in the eyes of law. At the cost of repetition, it may be noted that the direction to reinstate the respondent employee has already been complied with. In the interim, that direction was given. My lord, in this present case also, my lord, the prime element as to whether my absence was willful, that was the consideration for before the, my lord, disciplinary authority as well as the inquiry officer. Disciplinary authority has not framed any question on that. And the inquiry officer has also not come to such conclusion. And moreover, as per the inquiry report, I just placed, my lord, he spelled out the reason, my lord. The petitioner spelled out the reason at page 38, my lord.
Yes.
My lord, the petitioner spelled out the reason before the inquiry officer is at page 38, para 6. Reason why he was out from duty. My lord, third line of para 6, my lord. Whereas, important, my lord, whereas on the basis of statement of Constable Pankaj Bajwa, it is learned that as he did not know anything as to what had happened to him due to his mental stress or illness, because he received some injury, my lord, 22/12/2009. My lord, mental injury that normally, my lord, it aggravates later on, my lord, time to time. So far, my lord, I have heard from I discussed with the doctor also, my lord. No. And his statement, my lord, his statement that he was, the person he was, page 39, my lord, last two paragraph. Other witnesses have also said in his favor, my lord, on the basis of witness number 1, 2, and 3. Constable Pankaj Bajwa was found to be obedient to his duty, but no information could be found as to why he absconded. As per the version of accused, he absconded and remained absent owing to his mental stress or illness, my lord. This reason is before the inquiry officer. And if my reason is there and there is
You read further down.
sure, my sir.
As per the
Sure.
version of the accused.
Yes.
You did not produce any medical certificates.
My lord,
Nothing.
medical certificate, I admit, my lord, because he was unstable condition, my lord, and he could not, my lord, preserve those documents, which were my lord, only two documents, my lord. I'm just showing, my lord, only two documents at page 62 and 63. This is to, my lord. Admission date, my lord, 28/10/2011. However, my lord, these documents before LGB Regional Institute of Mental Health, my lord, he was admitted, he was given OPD number and on registration number. But my lord, these two documents, while his condition was deteriorated further, he was admitted in the mental health college. In the meantime, my lord, page 58. This is the, page 58 to give, oh no. Oh. My lord, not page 58, 47, my lord. Page 47. In the meantime, my lord, on 12 October 2011, they passed this order by dismissing the service of the petitioner. Lordship, in this order, Lordship will find page 47, last 4 lines, my lord. Page 47, my lord. Accordingly, the delinquent so-and-so has reported back on 1/7/2011. He reported of his own, my lord. A person reported of his own, therefore his mind is not there that I will never join duty, that is not there. In my humble submission, my lord. Hence, there was no other alternative with the inquiry officer except conduct inquiry ex parte. No, sorry. The delinquent again, no, I'm sorry. I missed that. The delinquent again deserted from Colony Line on 19/7/2011, on which that, my lord, his statement was recorded. And Lordship, total numbers of days of unauthorized absence, my lord, will find page 48, paragraph 6, my lord. Total unauthorized absence, they have calculated, my lord, 347 days. And this order was passed considering the inquiry report. And even the inquiry officer has not held that this is willful. Even the disciplinary authority has also not held, my lord, failed to held. And therefore, when were you admitted in the hospital
My lord,
after your accident?
after, my lord, this is just 2-3 days after the impugn order, my lord. Lordship, just 1 second. 28/10/2011, my lord.
No, 28/10/2011, that's as per the certificate, correct?
Yes.
That was page,
Page 62, my lord.
this is after you went and joined, isn't that?
Yes.
And then you absconded on
19/7, my lord.
but prior to that,
My lord, he could not place, my lord. He only said that my mental state is not good before the inquiry officer, but he was not having the documents, my lord, of treatment at Nolbari. While the parents brought him back, my lord, I have stated in the petition, due to his mental condition,
so you started taking medical treatment
yes,
only with effect from 28/10/2011.
my lord, as per this document. Because he must have.
Prior to that,
Huh.
after your leave expired on 4/2/2010,
My lord.
after your leave expired, that up to 4/2/2010, you were on authorized
My lord.
leave.
My lord.
All right,
Yes.
5/2/2010 onwards.
Yes.
You were never treated in any hospital.
He was treated, my lord. While he went to join again on 1/7/2011, my lord, he, my lord, misplaced all these documents on journey. He stated like this, my lord. But there must be, my lord, in my humble submission, my lord, there must be a person must having some problem of health. Otherwise, normal person will not go to check up, my lord. And this condition, mental health condition, will not deteriorate immediately.
Which hospital did you go for a checkup in Nalbari?
Mukundo Ram Kakoti Medical and Health, Medical and Health Hospital, madam. Mukundo Ram Kakoti.
Where have you stayed?
I have not said, but this is the statement he made. Well, so far, yes,
Where have you
that
made your statement?
Delhi investigation. Using mental health. Yes, my lord. Yes. Para 4, man. Para 4 last line.
Yes, yes. Hospital name I have not given, but my lord, para 4 of the petition. My lord, third line, my lord, due to the injury sustained in head, the petitioner started losing mental strength. Therefore, the parents of the petitioner brought him to native place at Nolbari. The respondent number 4 issued communication, my lord, and supporting documentation duty. And then the forsake how the petitioner brought him daily.
So there's no statement that you are
Yes, yes.
taking treatment.
Treated. So petitioner shown behavior. My lord, page 6, my lord. Para started with sub-para, my lord. As the petitioner shown the behavior of mental disorder, therefore the parents of the petitioner treated him in LGB Regional Institute of Mental Health Tezpur with effect from 26/3/2011 as OPD patient. His treatment start from 26/3, not on 28/10. And my lord, this OPD patient, he sought for the documents through RTA also because he's misplaced all the documents. They were not providing, my lord, the medical, mental health hospital, my lord. RTA এখন কৰিছিলো ন থাকিলে মানে এটা ৰিপৰ্ট এটা কল কৰিলে হ'ল দাদা My lord, now lordship kindly consider page 24. Page 24 is an RTI application, my lord. After misplacing his all medical documents, he sought for the documents from the LGB Regional Institute Health Tezpur, my lord. The documents particulars at page 25, particulars of information. Details of information request as annex 1. Period for which information sought for 2010 to 2016. Now, my appendix 1 is a page 26, my lord. And the certificate they have given page 27. Man.
Get your certificate.
My lord. This is to certify that Pankaj Bezburua is at about so and so. Hati Nomati PS Nolbari, Assam was admitted in this institute on 28/10/2011 for diagnosis treatment, but he got discharged on his request on 7/11/2011. However, on evaluation, psychiatric illness, he was found during the period of his absence. However, on evaluation, no psychiatric illness. He was evaluated as no psychiatric illness on my lord for that 20. This certificate issued on 26/11/2016, my lord. Down below. 26/11/2016. This is the medical board they held. In 2016, they found that he was not suffering from psychiatric illness. Following research.
No, not 2016.
My lord.
2011.
From 28/10/2011 to 7/11/2011.
However, evaluation, no psychiatric illness was found during the period of his observation. My lord. Following discharge, he did not come for any follow-up till 2011. On 16, he attended our OPD for medical certificate and he was advised to attend our next medical board, but he did not attend the medical board thereafter. Discharge certificate was given to him at the time of discharge from our institute. Now, my lord, my argument on the basis of this document, medical certificate, my lord. So for medical certificate, I also admit, my lord, the medical certificate is after the passing of the impugn order. No, that's why. Yes, If you can prove your point my lord, that from 5 to 2010 my lord. up to 1/7/2011, Right, when you appeared before the yes, departmental inquiry, my lord, that you were suffering my lord. and some treatment was done. Then this court would easily come to the conclusion that there was no willful absence from your side. It was due to circumstances beyond your control. Control, right, That is one part. But the Right. onus is on you now right. to prove that. My lord, so far the medical documents are concerned, my lord. These are, If you want, I can give you some time, my lord, then you can come back later on. Because this case practically is that you had an accident yes, on 22/12/2009. yes, After that accident, you hit your head and right, some parts of your body. got injured, After that, your mental imbalance started happening. So your parents came to Delhi, took you back to now. my lord, Then the issue starts. my lord, Then you took earn leave from 6/1/2010 to 4/2/2010. That earn leave was granted. my lord. There's no issue on that. Right, But from 5/2/2010 to 1/7/2011, 11, if this period you can show something, my lord, this court can come to the conclusion that there was no willful absence on the part of the petitioner. my lord. Any absence was due to circumstances beyond his
Beyond his
control, and therefore it cannot be counted as willful absence. That's one part.
Yes. I can try,
Then
my lord.
The
I can-
second part is from 19/7/2010, 11,
11,
till the conclusion of the disciplinary process.
yes.
When was the disciplinary proceeding concluded?
My lord,
Anyway, 12/10/2011 was the order passed.
Yes,
Yeah,
yes.
This is the impugned order, is it?
this is the improved order.
12/10/2011. And your certificate is 28/10/2011.
My lord. After,
These are some gray areas where you may have to fill up.
Fill up.
And then the court can come to a just decision. Otherwise, as of now, on the face of the courts,
yes,
there's nothing in your favor.
my lord. I understand, my lord. Let me take a chance whether I can get any documents in the
You
meantime.
can take a chance, there's no harm, let us, he's now out of service, isn't it?
This is
Out of service.
only
You are-
thing, Lordship, since he's going to try to take out some more documents to produce before the court. Now, Lordship, he says he met with an accident, 2009. There is no proof of any such accident that he has submitted because he was in Delhi. There are CRPF hospitals in Delhi where he could have been treated. There is nothing on record that due to his head injury, he was given a leave. There is nothing of that sort. If he had suffered a head injury, he was in the unit, Lordship, he had gone out, maybe when he was out, he met with an accident. That will be reported in the unit. Nothing of that sort, Lordship. Now, it is an afterthought that he is trying to make out a case on that 2009 I suffered with a head injury, and even the documents furnished by the mental health hospital says otherwise, Lordship. He was perfectly fine.
Okay. But the, my lord, whatever the petitioner spelled out before the inquiry officer, there is no afterthought, my lord.
Here,
He said about the mental stress or illness.
that is all right.
My ground is that, my argument is that, my lord, the reason was spelled out, that was, my lord, backed by the witnesses also, that was my submission.
Lordship,
Yes.
even in the case cited by my learned friend, Krishnakant Parmar, Lordship will note the paragraph 18, which he is relying upon. I would say that that is against him. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty. Fine. Including compelling circumstances beyond control like illness, so and so. Now,
Accident.
where is the material before this honorable court about that compelling circumstance?
No,
It's not
that's-
there.
That's why I'm saying.
Yes,
That's why I'm giving him an opportunity.
yes, yes, yes,
Let us see what happens.
yes.
But Mr.
I'll BK Das.
P.K. Das, level counsel,
Yes.
also heard Mr. R.K. P. Chowdhury, learned here for the response. Stop. When do you want?
My lord, at least 14, 2 weeks time, my lord. 2 or my lord, let me 3 weeks time, my lord. Or my submission is that my lordship has substantially heard the matter. Let it be part heard, my lord. 3 weeks, my lord.
Our third after.
Because
3
we
weeks,
have, my lord-
I'll forget the whole thing, we have to restart.
No, Lordship, it will hardly take time.
My lord, let it be after 2 weeks, my lord. 2 weeks then, my lord. Let it be part heard. Earlier also this matter was heard by several courts, my lord, but was not.
And I have to give a date,
Yes, yes, yes.
list the matter again on March
March, my lord. 2nd week, my lord.
14th,
That is fine, Lordship.
No problem. Yes.
14th March. That's what.
Lordship, subject to what Lordship says, Lordship, I have a small prayer, Lordship. In respect of the other item, Lordship, item 15. Lordship,
No, 15 is adjourned.
Lordship has observed none appeared. That might create some difficulty for me, Lordship. If it is not signed, Lordship.
Sometimes happen.
That's all right. In fact, that was a matter from SSB. I was attending a case of SSB itself in another court. I'm so sorry.
Let us see if we can help you out, but can we help you out?
If possible, Lordship, otherwise it's all right.
So now it's not possible. What can be done? Then I'll say on your request, list on sense.
Yes, that is fine. But if it shows I am not there, Lordship, I will have some
Okay, we'll try.
Lordship.
Oblige, my lord, oblige.
ঠিক কৰিব পাৰিলে হয় মিছা মিছি আৰু এদিন লগাম
ভালে হৈ গ'ল।
মোৰ কি ভাল হৈছে
14 তারিখে MU ওলাব আৰু। It is not 14 তারিখে। এইটো পাঠাৰ ৰাখিলে নেকি বাৰু? পাঠাৰ ৰাখিলে।
তুমি একদিন অফিচ পাবা মই এদিন অফিচ পাম
মই বহুত পিছ পাওঁ। আমি একেলগে concentrated 10,000, 12,000.
8,000, 10,000 অফিচ নকৰিবা এতিয়া
Fine, দাদা।